Hey folks, Bill Clanton, Consumer Protection Attorney. We're here talking about the Petrus case. This is a California case. It's a district court case. It's not an appeals court case. This is an opinion on a summary judgment case, summary judgment from the Nevada, the District of Nevada. This is a very interesting case, and it shows the value of having well-documented disputes and solid dispute letters. So Mr. Petrus is an autistic adult. He's been diagnosed with Asperger's syndrome. And the opinion talks more about that later on, and we'll get to more detail about that. But he was approached by a couple of fraudsters, a guy named McCullough and a woman named Whitfield, who they began discussing starting a business together. The plaintiff, Petrus, went into a Chase Bank branch location with Miss Whitfield and opened a bank account or credit card account with Chase Bank. He showed his state-issued ID and his military ID and opened an account, and she was listed as an authorized user on the account. Now, an authorized user is somebody that is not responsible for the charges on the credit card, but can make charges on the credit card. This is somebody who you know and like and trust, and you can add them as an authorized user on your account, and it can help increase their credit score. It's something some people do for one another. Sometimes husbands and wives will be authorized users on each other's accounts. Sometimes businesses will have employees as authorized users. So it's the function of an authorized user. Authorized users can cause problems in credit reporting because they don't always get handled properly. But that's not so much the case here. Okay, so around 2019, November 2019, the plaintiff started submitting disputes to Equifax and Experian. They were forwarded to Chase, and plaintiff said that he had never lived in Michigan, which is where Whitfield and McCullough lived, and he'd never made any transactions or charges in Michigan, where there was a bunch of charges that he had not authorized that were appearing on his Chase statements, and a Navy Federal account that they had opened up fraudulently in his name. Okay, along with his dispute letters, and this is what makes the case for the plaintiff here, because along with his dispute letters, the plaintiff submitted several other documents to the credit reporting agencies, including a police report. That's very good. A 2019 demand letter he sent to the fraudsters demanding payment. Text messages between him and the fraudsters, which he demanded repayment. Medical records regarding plaintiff's Asperger's syndrome. That'll come in really important later on. Chase billing statements, pages from plaintiff's credit reports, and a copy of plaintiff's driver's license. Now, this speaks to how well disputed these were. Including all those records should have helped Chase clear this up, and it certainly helps the court issue this opinion. The court, we'll get to that in just a minute. So in response to these disputes, Chase initiated investigations and found that plaintiff personally opened the Chase account using two forms of government-issued ID. The plaintiff added this Whitfield fraudster as an authorized user at the time it was opened. The plaintiff verified the validity of certain transactions on the Chase card in 2017, and that all transactions on the card not made by the plaintiff were made under an authorized user's name. So based on that, Chase said, sorry, these are valid transactions, and your dispute is not going to be honored. Okay. So he continues to dispute with the bureaus, and then on December 31st, 2019, TransUnion, he disputed with TransUnion, and TransUnion on December 31st, 2019 says, okay, this is a valid dispute, a valid ID theft dispute, and we're going to block this Chase account from your credit report. And so TransUnion honored it and blocked it, and the other two bureaus did the same thing, because they all have to work, they all share this ID theft information. Okay, so then Chase, then the lawsuit was filed. The parties engaged in discovery, exchanging documents back and forth, and then the case gets to the point where it's time for the judge to make a decision about the issues in the case before a trial. And so the parties' argument, defendant argues the undisputed facts show that Chase's investigation was reasonable as a matter of law. Okay, of course that's their position. Chase is always going to say that they did the right thing. Okay, so plaintiff argues that the tribal issues of fact exist regarding whether Chase's investigation was reasonable. Plaintiff argues the dispute was styled from the start as an account takeover dispute, and that defendant was on notice to investigate the legitimacy of the underlying transactions. And by limiting its investigation solely to the issue of account opening, defendant conducted the wrong type of investigation. Further, plaintiff argues defendant failed to conduct a reasonable investigation when it restricted its inquiry to its own internal records and declined to interview witnesses or assess plaintiff's claim that he was exploited as an autistic person. So the plaintiff is saying you should have looked at these medical records. You should have called the police department or the medical providers and verified this information. Okay, the court enters into its discussion and says it talks about the Fair Credit Reporting Act. It says when a furnisher receives notice of such dispute, it shall conduct an investigation with respect to the disputed information, review all relevant information provided by the credit reporting agency, and report the results of the investigation. So you dispute with the Bureau forwards it to the bank has to conduct an investigation based on what it received from the credit bureau. And that investigation must be reasonable. Okay, then the court goes straight to the central issue in this case, whether defendant conducted a reasonable investigation into plaintiff's credit dispute. Whether a furnisher's investigation procedures were reasonable is evaluated in light of what the furnisher learned about the nature of the dispute from the description in the CRA's notice of dispute. An investigation is not necessarily unreasonable because its conclusion is unfavorable to the consumer, even if that conclusion turns out to be inaccurate. So the court says, look, Chase could get it wrong and still do a reasonable investigation, right? Reasonable minds can differ about these issues sometimes. The court says that. But it goes on to say, the court finds a jury could conclude that Chase failed to conduct a reasonable investigation. First, the court is unpersuaded that the defendant was only responsible for investigating whether the account was opened fraudulently or without plaintiff's authorization. While the credit reporting agency notified Chase that plaintiff's dispute pertained to an account fraudulently opened, this does not mean the defendant did not have notice that plaintiff was also challenging the underlying transactions. In pertinent part, the plaintiff stated he was contesting delinquencies and inaccuracies and balances arising from charges that were incurred in Michigan, a place that defendant said he had never lived, never been to, and which was a home state of the alleged fraudsters, McCullough and Whitfield. A reasonable juror could find through these statements plaintiff was disputing not only the circumstances surrounding the account opening, but also the validity of the transactions. Okay. Further, the jury could conclude other documents received by the bank put them on notice that fraudsters were responsible for the underlying transactions. Okay, and this goes back to how well disputed what good disputes Petrus used in this case. The court says the police report, the text messages, the demand letters all indicate that the fraudsters allegedly fraudulently incurred charges on plaintiff's credit cards. Plaintiff's dispute letter indicates that the fraudsters took advantage of him. Okay, so that's all enough for the court to conclude that the investigation was improperly limited to the account opening. But the court says, however, even if this court were to assume the defendant was responsible only for investigating the account opening and not the underlying transactions themselves, a jury could still find the resulting investigation was unreasonable. Here, defendant did not contact a single witness. Not the alleged fraudsters, not the police department, not the plaintiff's doctors, not the merchants involved, or the plaintiff himself. Chase limited its investigation to its own internal documents, and courts have held that a reasonable investigation may require more than just a review of internal records. particularly when the internal records themselves have alleged to have been falsified or fraudulently made. Okay, the court goes on to say, a jury could therefore find it was unreasonable for Chase to not expand its investigation beyond its own internal records. The court finds this to be particularly true in light of the fact that Chase was on notice that plaintiff had autism and could be susceptible to manipulation. Now, again, this goes to how well disputed this case was and the information provided in those disputes. Chase was in possession of plaintiff's medical records, which reported that plaintiff is limited in judgment and insight, is dependent on his mother to support his day-to-day functioning, has a hard time making decisions, and has never been employed, and is not capable of self-support. So it would have been reasonable for a Chase investigator to at least call plaintiff to verify whether he seemed capable of voluntarily opening the disputed account. And they didn't do it. Chase only looked in their internal records to see that it was open with 2 forms of identification. There was an authorized user. They never looked at the plaintiff's capacity to do this, even though they were given police reports and medical records and everything else. So the court rejects defendant's argument that it would have required Chase to make a legal judgment beyond the scope of his duties under the Fair Credit Reporting Act. So they should have looked at all the documents that came in, and they completely failed to. So the court denies the bank's summary judgment motion. The plaintiff wins this one, and it's a great victory for plaintiffs. Viewing all alleged facts and inferences in light most favorable to the plaintiff, the court finds there is a genuine dispute of material fact as to whether Chase acted in reckless disregard of its statutory duty. Well, it's a great opinion for plaintiffs, and it goes to show the value of a solid dispute and bring a solid case against bad actors who don't do investigations. If you've been harmed by a bank's failure to do a proper investigation, then you may have a claim under the Fair Credit Reporting Act. This case was prosecuted by an attorney in California named Matt Locher. If you're in California and you have an issue with a credit report, you should look him up. If you have been through a situation like this with disputes that have not been honored or accounts fraudulently opened, put a comment below. Let us know. Let us know what that was like and what steps you took to dispute it and what happened in those disputes. All right, well, I appreciate you taking the time to watch this video. Thank you.